Thank you to the Council for giving us the opportunity to speak tonight. I speak as a local resident, a farmer, and also the President of the Australian Food Sovereignty Alliance, which is a farmer-led organisation made up of over 700 members nationally, working together towards a food system in which people can collectively determine their own food and agriculture systems. Really? As you know better than I, local laws are enacted across shires in Australia. The stated objectives in our shire include managing risk and nuisance to the community and promoting a healthy and safe environment. We've heard from councillors and council officers over the last few weeks that the law also helps manage council's liability should accidents occur where activities were not regulated, such as while salvaging materials from the tip, grazing animals on public land, planting gardens on nature strips, collecting firewood or foraging, amongst others. Under the Wrongs Act 1958, public authorities are given ample protection from being held liable for negligence. Sections 83 and 84 of the Act clearly protect public authorities by listing strict criteria that a plaintiff must establish to pin legal liability on the public authority. And to date, cases against public authorities have been largely unsuccessful unless the authority has a high level of managerial control over the situation that contains the risk of harm. In other words, the more control a local council assumes over an issue or area, the greater the risk of that council being found in breach of a duty of care. We also draw your attention to the point that WorkSafe responded to us to say that if you can negotiate with the council, you can safely allow salvaging at the tip. We'd also like to highlight the Productivity Commission's recommendations from the Regulation Task Force in 2006 that all levels of government should avoid undue prescription or regulation that is too blunt or disproportionate to the problem. Schedule 8, Section 1D of the Local Government Act provides that a local law must adopt the means of achieving its objectives which appear likely to involve the least burden or the greatest advantage to the community. It also asserts that any local laws enacted by council must be aligned with its own policy objectives. And as you'll hear from many tonight, members of this community have many concerns that local law number 2 is at odds with our declaration of a climate emergency and support for the ZNet program to achieve zero net emissions by 2029. It would inhibit farmers like us and other residents from pursuing our low carbon affordable solutions to things as necessary and common as pumping water around a farm and building garden beds, contradicting our shire and the state's well-established position to support artisanal agriculture. We recommend the establishment of a working group with representation from the diverse constituencies of our shire. We propose that the group includes, at a minimum, traditional owners, farmers, landless and homeless, low income, youth and women, and where one exists that they're nominated from democratically constituted organisations who have a mandate to represent their constituency. Thank you.